Good evening. We welcome you all to this fifth webinar series of Veda. The topic of today's webinar is consumer litigation, legal nuances. We are extremely privileged to have a very distinguished speaker amidst us, Srimati Lakshmi Prasanna Chodavarapu, member, District Consumer Forum, Hyderabad, Government of Telangana. We extend a warm welcome to you, ma'am. We would like to inform you that you happen to be the first woman speaker of a webinar series. Incidentally, we had started our webinar series with a woman-centric topic, namely inheritance rights of a daughter. And then we are happy that finally we could open a woman speaker for our webinar series. To briefly introduce the topic to all of you, on March 15, 1962, President John F. Kennedy spoke about 4 basic consumer rights in the US Congress, which were later expanded into 8 rights by the United Nations. Therefore, March 15th is recognized and celebrated all over the world as a World Consumer Rights Day. The 8 rights that were enumerated as consumer rights are the right to safety, the right to be informed, the right to choose, the right to be heard, the right to satisfaction of basic needs, the right to redress, the right to consumer education, and the right to healthy environment. The UN Conference on Trade and Development have emphatically pronounced consumer rights as a cornerstone of inclusive development. Our own indigenous legislation happens to be the Consumer Protection Act of 1986, which was later substituted by the Consumer Protection Act 2019 to provide for the various latest developments happening in the consumer market. Without much ado, I now call upon the speaker, Srimati Lakshmi Prasanna Chodavarapu, to address the audience on the topic consumer litigation, legal nuances. Before that, I request my colleague Kriti to give a brief introduction of ma'am for the benefit of the audience. Over to you, Kriti.
And government, Uniform Civil Code, medical negligence, prohibitory injunction, information disclosure for government departments, music and law, and many other subjects like that. Ma'am has also given multiple seminars and workshops in State Bank of India to the staff of the bank, in HRD Ministry on women-oriented subjects, and has submitted multiple papers like subjects like working model of legal aid center, as well as a review of land laws by the government of Telangana. Ma'am has initiated her working in a New York-based legal firm called Quizlex, and thereafter joining tri-legal firm in Mumbai. She has been empaneled as an advocate for State Bank of Hyderabad and State Bank of Travancore. She has been appointed as a legal consultant thereafter for the Ministry of Panchayat Raj, the Government of India. She has worked as an assistant legal advisor for AP Transco for 2 years. And she has also been empaneled as an arbitrator with ICADR. Further, she has worked as a consultant in the Center for Good Governance under 2017. And now, as all of you know, she is working as a member in the District Consumer Commission. I have to mention that Madam is a multifaceted individual who is also proficient in Carnatic classical music and playing the Veena. It takes all the breath out of me to mention all the achievements that Ma'am has had and everything that Ma'am has learned so far. I think it's a wonderful opportunity for all of us to share this seminar with you, Ma'am, and learn a lot from you. So I would like to welcome you without further ado so that we can take the best of this opportunity to learn from you. Welcome, ma'am, and thank you so much for joining us.
Thank you so much.
Yes.
So namaste, and welcome you all who have joined in the session. Thank you, Swati, thank you for the introduction also. And I'm sure you people will accomplish much more with all the learning and experience and exposure you have nowadays. So hopefully, by God's grace, all of us are coming back to normalcy after the 2 years of pandemic. So having been in mainstream litigation for more than 10 years and then into consulting freelance consulting, especially providing proactive legal services to the government through Center for Good Governance, mainly on public procurement and tender analysis. Thereafter, now working as a member in the Telangana District Consumer Commission at Hyderabad, I thought I can share my learning and experience both at the bar and the bench. So rather than walking through the provisions of the law, I thought it would be more interesting to discuss cases wherein I have passed some orders in the recent past pertaining to cases of deficiency of service, defect in goods, insurance matters, medical negligence cases, and also banking services. So before going ahead with the topic, I would like to just take you across to the first slide where one of my articles has been published. So that was the first article. This was an article I wrote after my first hearing of a complaint against an advocate for the deficiency of services. So before sitting on judgment about on the deficiency of services by other service providers, I thought we should first understand our responsibility as legal professionals towards the clients. Although the liability under the CP Act is still being debated and is under the scrutiny by the Supreme Court. I know that failure to choose the best strategic course of action does not necessarily amount to breach of duty of an advocate or, for that matter, any other professional. While client's dissatisfaction is very common and every potential loss of a legal claim cannot be attributable to service deficiency, nor can we guarantee about the outcome of any litigation. However, when we are paid for the services and when lawyering has become a business and when nobody is above law, I think justice demands that legitimate claims are to be heard by appropriate forums. Having said that, I would like to just mention a few points where we are found wanting. I think it's there in the second slide where actually what we are looking for in advocates and where we are found wanting by the clients as well as the service providers. So starting from giving a proper applicability of the law to the client situation, drafting, default of non-appearance, and collation of evidence, and also funds misappropriation and breach of confidentiality. There are some complaints about these things. Anyway, when we are discussing about the cases, I think we can really discuss threadbare about these aspects of advocacy. So coming to the new Consumer Protection Act, considering the internet penetration and massive use of smartphones and growth of e-commerce through online transactions and digital payments, and to address the market dynamics involving various stakeholders in the supply chain management, there was a need for a comprehensive legal framework with rules and guidelines to regulate and provide effective redress mechanism for consumer protection. So I find that there are 2-3 provisions as the law currently stands. One is the section, can you just take me to the third slide, please? Fourth slide, I think. So the key features of the consumer, so apart from the mediation annexed to the consumer fora, and also the penalties of misleading advertisements, and also the review power provided to the district commissions now under the new act, the main major areas where I found is the provisions of unfair contracts and unfair trade practices under section 2, subsection 46 and 47. So this basic test for any unfairness is when the contractual terms are non-negotiable, they are contrary to the requirement of good faith, causing significant imbalance in the rights and obligations of the parties to the contract, especially detrimental to the consumer. So it is only indicative and not exhaustive list that, as you know, the list of terms which may be regarded as unfair are penalty clauses. These, we are going to find in discussing the cases in the next few minutes. So there are some cancellation clauses, unilaterally cancellation clauses, discretion of the seller or the vendor or the service provided for price escalation, and also variation of clauses as per the terms and conditions. Similarly, under the unfair trade practices, there is false representation or misrepresentation regarding the quality, performance, users, benefits for the purpose of promotion. You can just see some of those unfair trade practices which we have in the just given slide there. Product liability under Section 82, from Section 82 to 87, is a major amendment, a major contribution of the new Act, where the product liability resting with the manufacturer, starting from the manufacturer to the service provider and also to the retail seller. So after sales, including the after sales services, I think the product liability covers for all deficiency of services under the Consumer Protection Act. So now to discuss about the consumer protection, so the cause of action. The cause of action is generally triggered whenever there is defect, any fault or imperfection or shortcoming in the quality or quantity or the standard that has been expressly provided in the contract or under the warranty. Similarly, deficiency of service is any sort of fault or imperfection, shortcoming or defect, or quality, amount, nature, worth, authenticity, capacity, and standard regulated as per the laws of the standard or as per the terms of the contract. Now, coming to the unfair terms, as I have discussed, we'll just go to the flow chart where the flow chart of litigation is there, where the filing of the complaint and then next notice is served to the other side. So in two scenarios, when the notice is served, when the respondent appears or not appears, then it is set ex parte when the opposite party is not represented. So that's how the flow of litigation goes on, filing by affidavit by both complainant and the opposite parties, and marking of documents, and the evidence is taken chief. Actually, the litigation under Consumer Protection Act is more advisable for summary procedure, but now we follow all the civil procedure CPC rules and practice. So it is becoming a prolonged litigation as like any other civil court. So now coming to the nitty-gritty of litigation strategies and preparations at all stages of an action. So the first slide of my cases I will discuss under the unfair trade practices. This was a case. It's a complaint regarding the internet handling charges for the online purchase of movie tickets. So the complainant allegation is that consumers are burdened with operation of the service by charging extra over and above the actual ticket price. Now the internet handling charges are inclusive of online booking facility charges and GST. So in support of his claim, the complainant has filed various RBI circulars and replies to his queries to the statutory authorities under RTI, including MIETY, regarding the payment gateway charges for online transactions and the range of merchant discount rates for various online services. The contention of the OP was, in addition to the preliminary objection of maintainability, as the subject matter of pricing online prices was a sub judice matter before the High Court of Andhra Pradesh and Telangana, and also High Court of Bombay. The services are optional. The contention of the opposite party was that the services are optional, transparent, giving an informed choice to the consumers for online booking for the value-added services, that is saving time and also trips to the theaters. So we found that the passing on the cost, the issue before us was whether the passing on the cost to the consumers in the form of internet handling charges, especially when the merchant discount rate charges as per the circular of the MIET it was absorbed by MIET and it was subsidized by the bank for digital transactions. So the preliminary objection as to the maintainability that it is sub judice was also overcome by stating that this remedy before the Consumer Protection Act is an additional remedy to any other alternative remedy before other courts. So that's how it was allowed, and it has been in the newspaper also, it was also reported. The second one is the complainant was the complainant paid an amount of about 2 lakhs. I have provided the hyperlinks to all these case laws also for the kind perusal of the participants here. So the facts of the case are that the complainant, the second one, he has paid an amount of 2 lakhs 95,000 towards earnest money in pursuance of purchasing a flat which was priced at 3,500 per square feet along with GST at 12%. Subsequently, he paid that in the month of January. Subsequently, in the month of April, he came to know that the GST has been reduced from 12% to 5%. So that he approached the opposite party to avail the benefit of the reduced GST. It is the allegation of the complainant that the OPA has escalated, revised the price from 3,050 to 3,273 with the GST at 5%, thereby adjusting to match the total cost of the flat. So because he was unwilling to pay the revised price, he withdrew from the contract. He withdrew from the contract, and it was not a contract. It was not a concluded contract. So he sent a mail asking to cancel the booking of the flat and refund the amount. So in pursuance of that, he approached the consumer court seeking appropriate relief. So the opposite party's contention was that there is no concluded contract, there is no binding contract between the parties. They have also refunded the amount, and the complainant has already acknowledged the receipt of the amount, advance payment that has been done. And hence, there is no cause of action. So in this particular case, I was thinking that had the advocate approached the court, had the complainant approached the court without withdrawing from the contract, perhaps we would have provided a relief for him not to violate, because there was a finding, initially there was a finding that he has violated by maintaining 12%, although the input tax credit was has to be passed over to the consumer. He maintained the 12% GST. So on that account, we found him guilty of violating the GST Act, CGST Act. But however, the complainant was not entitled for the relief, having withdrawn from the contract and also having received the advance amount. But there was no binding contract between them. So that's how we thought that the advocates should have come to the court prior to withdrawing from the complaint. Right. So then the next is an interesting case about unfair terms and contracts. This was a case filed by the complainant for refund of fees of 2 lakhs paid towards his son's admission into 2 years integrated program offered by FITGI for his son who could not join the course classes due to relocation to another place. As the OP refused to refund, stating that it is non-refundable, he approached the forum for appropriate relief. Now, as is the case in all standard contracts, the OP contended that the complainant signed the enrollment form declaration consenting to the terms and conditions therein. The preliminary objection was that education is not a commodity and the student is not a consumer under the Consumer Protection Act. Relying on Udaya Lanka Sadan and Maharishi Dayanand University versus Sujit Kaur Kosi case. So there are two streams of opinion on the question whether student is a consumer and whether education is a service. as defined under the Act. While clarification is needed from the Supreme Court regarding the statutory and non-statutory functions of the educational institutions, considering that under Section 65(27) of the Finance Act, commercial training and coaching centers are distinct from educational institutions, that they are imparting skills and knowledge on any subject without issuance of a certificate, and under 66D of the Finance Act, service given in the negative list category 12, it was also categorically mentioned that coaching centers are not educational institutions. So on that finding, on that statutory interpretation, we have allowed the complainant, and the OP has already charged a service tax on the fees it received from the complainant. So as held in the brilliant tutorials versus Ashwini Verma, the National Commission, that charging fees in advance beyond the current semester would certainly amount to unfair trade practice and cannot be countenanced, we allowed the complainant. So this was a typical case where
it has developed its process.
There was no meaningful choice to the consumer. This was a one-sided contract that made us allow the complaint, finding it an unfair term. Similarly, there was another case where the complainant has paid 9 installments for purchasing a plot under a scheme, and after that it was revised from 4,000 to 12,000, which was unreasonably high, and he withdrew, filing an affidavit for refunding of the amount. So the main contention of the opposite party was similar, that he has on his own volition he has signed on the dotted line. So there was he cannot be refunded, and it is unrefundable. So in that, again, we found that it's an unfair trade contract, having no meaningful choice to the complaint. So the next is about the deficiency of services. This is these are non-clinical services. This is a complaint about the non-clinical services where the complainant has suffered an injury, and he approached, he went to the hospital, and his complaint was he was taken, as there was no MRI available in the hospital, he was taken in an ambulance to another hospital and another diagnostic center. His complaint was the ambulance was not comfortable, the stretcher where he was carried was not comfortable, and other things. So because of absence of evidence substantiating his claim, and there was evidence rebutting his claim by the opposite party about the compliance of all necessary safety measures, and also the standard of care that should be provided by any clinical establishment, we dismissed the complainant. The next one is a very interesting case where the complainant purchased a laptop which developed a lot of issues of display, and it was getting heated up within 1 month, and he took it to the service dealer, where it was repaired and also formatted, but there were recurring problems within 1 year, and he suffered loss in his business, and there was proof of the loss in business because of unavailability of the computer services also. So we allowed that as because after sale services are collateral within the warranty period, and hence we allowed the complaint. So coming to medical negligence, I will just first discuss about the second case, that is an eye operation, I'll tell you, this was a very interesting case because we found that the expert opinion, which was required for almost all medical negligence cases, we found that there was the expert opinion was against the complainant. It was favoring the opposite parties, but despite that, we allowed the complaint because the complainant was an agricultural laborer who had a problem with her vision, and she went to the opposite party hospital where she was operated for the right eye. And in one of the medical records, we found that the evidence was really very clinching. In one of the medical records, they found that at the time of admission, they found that her left eye had hyperopia and there was a swelling. There was an injury to her optical nerve, which was not rectified during the operation. But subsequent to that, they suggested and advised for an operation post to the first operation, which could have been avoided had there been a earlier diagnosis of the prolonged, at least the earlier diagnosis of her problem. So she suffered, and we gave her, we allowed the complaint, and we gave her award of 2 lakhs. So that was one of those medical negligence cases. I think I'll discuss about insurance now. So the insurance, the first case is about a pre-existing. Most of the insurance claims are repudiated on two major grounds. One is the non-disclosure of some material facts, or the non-disclosure of a pre-existing disease. So there was a complaint whose insurance was repudiated on the grounds that he had tonsillitis, which he suppressed at the inception of the policy. But in fact, the doctor's certificate, the discharge summary has clearly mentioned that he had a throat pain, which was there for the last 2 years, but the tonsillitis was only diagnosed in the last 90 days. So I think that was a baseless and false a pretext on which the insurance company has repudiated his claim. The second one was an interesting case where the grandfather of 2 minor daughters was the complainant. He approached the consumer forum when the insurance of his deceased son was rejected on the grounds that one of his insurance policies, which he had prior to the inception of the present policy where he is claiming under that policy, was not disclosed. So during the evidence and in the inquiry, we found that there was really we should say the bona fides of the complainant was very clear in disclosing about 6 insurance policies that he already had. Only one policy, I think it was inadvertently, it was not disclosed because he was an illiterate person. So although there was a decision by Justice Chandrachud that any suppression of material fact, because it is based on good faith, all the insurance contracts are strictly on good faith. But in this particular case, we found that there are bona fides of the complainant, the insured, when he has already disclosed 6 of his policies and only one policy he would not disclose. He allowed by giving a direction to settle the claim and also pay the amounts of 5 lakhs and 10 lakhs under 2 insurance policies. That was a really very good judgment. I hope it will be carried to the Supreme Court so that there will be a better appreciation of this. So coming to the banking, the non-working of complainant's SBI MasterCard. So this complainant had a debit card and a credit card, which he carried with him to London. So after going there, he used the debit card, which was not working. One of the debit cards was swallowed by the ATM machine. So he immediately called the people here in Hyderabad to his branch, a bank, and asked to the card, complaining about the debit card that has been swallowed. So immediately it was blocked. So there was no unauthorized. The case is not that there is an unauthorized use of his debit card, nor was it a case where there was any failure of the transaction. So it was only whether it is attributable to the bank people who had no control over the ATM in London. And also one of the debit cards was not an international card. So although he was a senior citizen and he was really upset about the whole episode, we couldn't allow because the evidence was not supporting his claim. There was another case. This was the contents of the locker. There was a complaint. The allegation is that she lost the contents of the locker. There were 2-3 gold bars, and also there was some jewelry. So they filed an FIR, and after investigation, the police found that there was no fraud or any theft in the bank. So although she has come forth with photographs of all the contents, saying that they are contents of the locker, there was no such establishment. But I heard that there is an RBI circular very recently stating that if the fraud or theft is attributable to the bank employees and establish a case against the bank, then their liability is only limited to paying 100 times the annual rent of the locker. So that is in a very recent, in pursuance of a direction from the Supreme Court, I think the RBI has issued a circular notification recently. So what I would like to summarize in all my cases is the burden of proof is on the consumer, on the complainant first, to establish prima facie that there is a case of negligence or deficiency of service on the opposite parties. If there is a duty of care, then whether there is a breach of contract as per the terms of contract, and what is the loss or injury caused to the complainant, the causation, and the standard of care and expectation, the professional skills and expertise, the evaluation of evidence is very important. And there is a limited liability in most of the contracts. The loss of damages are incurred. What are incurred by the complainant will be determined in adjudication of the company. So thank you so much. So any questions, any queries, please let me know. I'm available.
Thank you so much, ma'am, for that enlightening session. Kriti, have you received any questions?
I have received a few questions, ma'am. I will read them out to you so that you can answer them.
Participants are requested to forward their questions to Kriti on the chat box, or if you are comfortable, you may ask ma'am yourself. You may unmute yourself and then pose a question to ma'am. I think that will be very interesting if you could speak to interact with ma'am directly as well. Meanwhile, Kriti, yeah, so Subbarao, yeah.
Good evening, ma'am. Thank you for the beautiful session. I have a question, ma'am. Can a consumer complaint be resolved through mediation? And
yeah, in fact, pending litigation, we have come across a lot of cases where cases are settled out of court by the advocates and parties themselves. Even in the execution applications, it so happens that disputes are still continuing. In fact, they trigger a fresh cause of action because they have not complied with the order. Even in those cases, the advocates facilitate in resolving the disputes and settling the matter out of the court. That's how things are compromised also most of the times.
Even at any stage, ma'am?
Yes, definitely. Now actually we have a panel of mediators annexed to the consumer fora now, where they are referred, if both the parties are willing for a neutral party to mediate.
Are these mediators supposed to be certified mediators, or can any advocate impanel?
Yeah, not necessarily. Mostly they are subject experts in insurance and medical field also. There are mediators who are coming forward in multidisciplinary sectors also. Yeah, from field, insurance, banking. So it's not necessarily that they have to be certified arbitrators.
Okay. So, I mean, you can volunteer. What is the process of selection, ma'am, to be empaneled?
Mediators constituted by the appropriate under the Act. So either the parties have to select from them, or they can themselves propose a neutral party agreeable for both of them.
Thank you.
So, ma'am, I will read out a few of the questions that we have received. The first one is, can a consumer file complaints online, and what is the procedure for it?
So e-filing is already introduced through the new Act. And also earlier it was that the complainant has to file in the place where the opposite party resides, or the business quarters, headquarters of the opposite party are there. But now the Consumer Protection Act 2019 categorically allows the consumer to file from any place where he resides. E-filing is also allowed. However, because it is in the nascent level, there is more of manual procedures in addition to the e-filing. So there's still some gaps to be filled before e-filing really takes over.
The next question, ma'am, is, in your experience, which area in consumer litigation is most active? For example, like real estate or retail, etc. What is the position of litigation against e-commerce?
So the e-commerce rules are very clear now, fixing the liability on all the stakeholders of the supply chain management, starting from the manufacturer, information that has to be disclosed regarding the details of the product, the contact details of refund, for refund or return of the articles. So we do get, there is also this fallback liability of the service provider as an e-commerce entity, whether as a platform that is providing for the vendor to sell his products, or as a legal entity which themselves spend the sell the products. So there is now the liability of all the stakeholders, including the service providers and also the after sales dealers. Everybody is now liable for any kind of deficiency of service or defect in the goods. So it is it's a very the scope and ambit of consumer protection has really enlarged that way.
Because we are on the subject of e-commerce, ma'am, there's something I would like to point out, because during the pandemic, there are a lot of home businesses that have started up on social media forums where people are staying at their homes and selling to people over platforms like Instagram or Facebook and other such social media platforms, or WhatsApp. So the thing is, it's very difficult to identify and find where these people are coming from. If there is an issue, if there's a defect with what they have supplied to us, how do we reach out to them? And they don't properly give you a set of guidelines or something to follow. So how do I take my grievance against these persons if they're not exactly identifiable, or give me any procedure to get hold of them in case of an issue? How does the statute help me under such circumstances?
So as I told you, the fallback liability is on the platform, the e-platform, which is providing the platform for the seller. So the seller is always registered, and there is a implied contract between the seller and the e-platform. So if you have any comment, the point of contact for you will be the e-platform only. So he is jointly and severally liable for all deficiencies or defective in defects in quality, design, or whatever has been the terms and conditions of your services or whatever it is, they are equally liable. So they are jointly severally liable, unless the contract specifically expressly mentions about limited liability of the product. But the information regarding the product has to be disclosed clearly for an informed choice of the consumer. Yes.
To just expand on what you were saying, ma'am, these WhatsApp groups, I hear there is no liability in the sense there is no information provided as to who the seller is. And most of these are like WhatsApp and Facebook. Till date, I don't see any litigation which has come against Facebook and WhatsApp.
Yes.
But do you feel there is an opportunity there? We can always file against Facebook. And
yes, I think e-commerce rules provide even for all social media networks also, where people are advertising about their products, about the liability of the sellers, even on social media. Yes.
I think in this specific area, there's an issue with dissemination of information about what consumer rights are to the general public. I think that is somewhere we're quite lagging in providing information to the general public.
That's right. Yes, awareness, although it has really improved a lot, but still we need to really educate consumers about the various rights they have regarding the quality, and also the consumer awareness has to be improved.
Ma'am, would you suppose that this would be a duty of the statute to some kind, in some way, to address it, the education of public?
Yes, the consumer protection councils are actually meant for promoting the consumer protection through awareness programs, conducting awareness programs and workshops on these kind of things. But I think advocates will have to really gear up to understand the legal nuances of the latest e-commerce business. Yes.
Namaste, ma'am.
Yeah,
I'm Padmavati. I'm sorry.
Yes.
Padma, you have a question?
Yes.
Yeah.
On the same grounds, actually, as ma'am said, she said that those WhatsApp sellers will be registered. But to be honest, I have done that sari business, selling saris or dress materials online through WhatsApp. But I don't think those sellers are registered, ma'am.
On social media?
Yes.
How is it?
I mean, they just start it up. At least I was not registered. I did not register under any platform saying I am doing so and so business. So basically, it is just a business that you start up, creating a WhatsApp group and sharing your products, and whomever joins your group and feels they want to buy so and so product from us.
However, you are paid some consideration, isn't it? And the person who buys will become a consumer.
Right, but I mean, you said that they will be registered, but there is no registration process per such.
Yeah, mandatory to register even in social media, as I heard. But, anyway, but because he is a consumer, I think he has a right for redressal if there is any issue with the sale purchase.
Okay.
Here there are multiple sellers, not just one seller. It's a chain of sellers it's a very informal setup where you're not registered as a business entity in the first place. It's like just a WhatsApp user has created an informal group. So I think this is a very gray area which is yet to be addressed. It happens to be a very informal because there are because what you see, like in the common photos, suppose you don't get what has been promised by the seller, the consumer is at a loss because the seller is denying any liability.
The seller puts up a set of rules in the start itself saying returns won't be accepted. There will be color variation. I mean, he will set up those rules based on his convenience. So the consumer is nowhere given even the chance to even question. So it is actually a very unfair business, to be honest.
Quite true. Quite true.
I think we have to pull up such businesses out.
Okay.
Subaru, you have something to say?
Even consumers should also be aware of those unregistered sellers and all before they going to purchase, or they should be aware about that unregistered sellers and all on social media,
Right,
especially
but
on social media platform.
exactly what you said
It's
is
not
very
on,
true. But
yeah.
unfortunately, as a lame user, you won't have all this awareness. And when you see, I mean, I joined that business. I started my business, and I returned money whenever my customers did not get what they were supposed to get. So I did it fair and trade. But once when I got deceived by one seller, I totally stopped that business. So as a lame user, you won't have all this awareness until you get really cheated, you know. So
Actually, from 1986 to 2019, there is a great expansion in scope of consumer disputes and redressal and all. Hope for better expansion scope in this area also, as
That's
ma'am
right.
said. As ma'am
That's
said,
The problem with technology is that
yes.
otherwise cyber crimes are untraceable. It's very difficult to trace committed the crime. So, and these are like small things which usually get a lot of people don't reach the consumer forums. They don't approach the consumer forums because amount involved is very little. The various, and maybe they don't, the litigation is a long process. They don't want to, follow it up and all that. So there is a need for more, I think, online kind of thing, online ombudsman or online litigation forums which can resolve consumer disputes. But I think this is a very genuine cases that are coming up more and more. So unless an online kind of solution is found for such issues, it is difficult to pull up such cases and find a redress.
I have another question, ma'am. Can I?
Yes, go
Yeah.
ahead, go ahead.
Can you explain about applicability of CPC, ma'am, to proceedings under Consumer Protection Act?
Oh, as of now, although it is advisable to have a summary procedure that take only the documentary evidence into consideration while adjudicating the complaints, we have been almost following all the CPC rules. For example, the notices, serving of the notices to the execution of the applications, and even in the enforcement EA proceedings also, I find that again 251 CRPC comes into play, 317 comes into play. There is an evidence, there is examination and cross-examination of both the parties, again the complaints order. And the flip side of it is the NBWs have been pending for non-compliance of the orders for the last more than 10 years. Unfortunately, the person has an order in his hand, but it is very poor implementation of the orders for reasons best known. I think that is an area where we will have to really bring reforms, making it more simplified, simple procedures for people to understand, and just the consumer comes and it's a summary procedure, just look at the merits of the case, whether due to allow. Even in the execution applications, I think if they are complying or if they are going to an appeal, then there is kind of those two are the only options available to the respondents. It shouldn't be that again you reopen the case as if there's a fresh cause of action. It's happening like that, but I think we need to work on that area. Yeah. And the second thing is there are n number of interim applications filed by these people for cleaning up what they haven't done at the time of filing the case, for amendment of the starting from the cause title to the relief they are asking. Apart from interim reliefs like asking for not to seize the vehicles or those kind of things, of course they are really genuine applications, but there are n number of interim elements just prolonging the litigation by both the parties. So these kind of things I think need to be really ironed out.
So, ma'am, I'll move on to the next question from the audience.
Yes.
You had mentioned about banking frauds. What is the position of banking ombudsman vis-a-vis the consumer forum?
So the award of the ombudsman is considered as one of the admissible evidences, but still without prejudicing prejudice to the rights of the people, generally we look at fresh the merits of the case and also the evidence that is filed by both the parties. The ombudsman is not generally binding on the consumer authority. Yes. See, the award of the ombudsman or the findings of the ombudsman are taken into consideration, but we determine and examine the facts of the case.
Ma'am, the next question is with regards to section 21(2) of the new act, ma'am. Here it penalizes the endorser who is endorsing a certain product. To what extent is it fair that an endorser be penalized for something that he's contractually obligated to do by the original product owner?
Yeah, but can you tell me how is he liable for the false or misrepresentation of the advertisement?
See, ma'am, from my perspective, I do understand that if somebody is being an endorser of a certain brand or a product, he ought to have some kind of reasonable human understanding of what would be appropriate to project before the audience or what is not appropriate or what would be misleading to the public. However, most of these people endorsing the brands, they do it because of a certain position they're in and they're under some kind of a contractual liability with the company that is owning the product. Sometimes they're told what the product is, whether they in a place where they're able to apply their prudence, and in some circumstances they sign the contract and then they're made aware where if they do not agree with it, they would fall under certain liability for that contractual violation. So is it fair that this endorser, when in most circumstances he's like a subordinate party who is taking command, should he be made liable to penalties like 10 lakhs or amounts of the like?
What do you think if this is a disclaimer by the endorser saying that he is not really he doesn't have really appreciate the product, or he's only doing it for the contract? This is a contract of service between the advertiser and the endorser. So those kind of things, yeah, these are issues that have to be looked into when the endorser is held liable. Yes.
Also, there were a lot of advertisements. I remember over the last few years, there have been a series of like a row of advertisements where they were showing like Harpic to wash your hair, where teenagers go pick that up and wash their hair and try these experiments by just watching advertisements, which are intended to be in a certain line of humor. They never. What?
Yeah. That reason, the CCPA, the Central Protection Authority, Consumer Protection Authority, has been established to regulate all these misleading advertisements and also to discontinue. They have passed many orders in the recent past. I heard proactively, suo moto, they have passed many orders against these misleading advertisements to discontinue. That is a thing that they under the new act. Yes.
So, ma'am, another question is with regards to the point of educational institutions that you had brought up. It is, as you had stated, that there is pending opinion from the Supreme Court on the educational institutions. What would be your opinion as students are paying fee and are expecting a certain service of certain standard from schools? Can they still be made liable in case of any failure on those grounds?
Yes. Particular case where I have really found that the services are two different aspects of statutory services and also non-statutory services. So if they are found there is a deficiency in services by the educational institutions, I think educational institutions has become commercial business now, and especially the coaching centers which only impart the knowledge for the entry without giving a certificate the course that they are those type of institutions are not protection. Well, we are waiting for some such kind of decision by the Supreme Court. But as of educational, there are two schools of opinion about these things. Yes.
Because it appears that there are a lot of complaints saying that nothing is there in the new act with regards to educational institutions like schools or as a separate entity from coaching centers also. Even schools are considered on the same ground.
Yes, yes. There's nothing regarding the educational institution per se.
And ma'am, I have a question with regards to that case that was specifically mentioned with about the eye operation of an individual, which you had said specifically that there was nothing in the evidence or a statement from the expert that something went wrong in the operation. It was something
No.
that
The expert committee has said that there was nothing wrong with the operation. The operation is successful and everything. But while in the inquiry, we found that one of the medical records was saying that at the time of admission only, she had a problem with the left eye, which was left unoperated, and only the right eye was operated. So she developed that infection to the left, and a lot of medical literature was really, I think you can access that decision, and you'll really find it very interesting. Yes, there was evidence showing that there was negligence on the part of the, so we gave a direction to rectify the problem along with compensation.
Okay, I understood. I will go through the document that you were attaching.
Yes, I have given you the hyperlink also.
Ma'am, in continuation of the question which Kriti asked, like over the last couple of years of your tenure at the bench, like on medical negligence per se, like what has been your experience, ma'am? Like at some level, like this COVID pandemic has taught us that doctors were the front warriors because of whom all of us have been like able to survive a pandemic. Are there like false complaints being lodged against hospitals, or you find them genuine cases where these corporate hospitals are like high-handedly denying the genuine compensation to the patient? Like what's been the general trend at the forum, like on the issue of doctors' negligence?
Yeah, most of the medical negligence, we find that there is no clear evidence to fix the liability or to prove the negligence. That is the biggest problem. In one of those cases, I'll just give you an example. It's also another ophthalmological case where the person was operated and he said went for the second checkup. So for the second checkup, in the follow-up thing, he fell down from the wheelchair where he was actually taken for some small checkup. So he underwent a fracture, orthopedic surgery consequent to that. So he claimed compensation for that. Unfortunately, there was no evidence to show that there was no attending, there was nobody attending to him, or he fell down from the wheelchair because of negligence of the doctors over there. So we only gave a direction to install CC cameras, at least to prove or disprove whatever is the requirement in that case to adjudicate. So we gave such a direction, giving a very nominal compensation to the complainant. So it's more about evidence in medical negligence, which is really very, very difficult to establish. So most of the time, it is the expert opinion we rely on. In some of the cases, there is, as you know, ipsi loquitur kind of a thing where it is palpable negligences on the face of it. We can really make out if there is some negligence by the doctors.
And the liability is normally attributed to the corporate hospital, or like a joint and several liability to both the doctors
and also the strict liability of the hospitals is also taken into consideration. Yes.
And actually, thanks a lot, ma'am. Like all the case laws you've referred to during your session, we were very grateful to you, because each of those cases had amazing insight. Like all of us today, after listening to your session, were like one issue about how you looked into the Finance Act to determine how coaching centers would fall under the ambit of service. I think that's something.
That's really very true. We need this multidisciplinary approach for solving problems. It is more about problem solving through multidisciplinary approach rather than focusing on the technicalities and procedural aspects of law. Yes, very true.
And the last issue you highlighted earlier, ma'am, about execution proceedings in the consumer forum pendency for the last 10 years. Now that the new act has a slight change in the regime, where I think the orders passed by the district forum are treated as a civil court decree. Would this make a change, or like would this be a game changer, or it's still continuing to be the earlier problem continuing in a different form?
I wish the concerned authority really brings in some kind of enforcement mechanism, like how there is in civil courts to enforce the orders. It's really, really very pathetic. I should really realize that it's so bad that NBWs are pending for so long, and the consumer is really at loss, even with having a favorable decision in his favor. Let's hope it's not on paper and it really translates to something like that.
So, ma'am, I just have one question from the practical aspect. This is not so much on the consumer forum front, but I just ask out of curiosity, because you mentioned that there's this involvement of multidisciplinary knowledge. What is it like from your perspective adjudicating when there's a lot of technicality involved in multiple different fields? Does it become a lot to assess, and how do you approach when it becomes that heavily technical?
Yeah, personally, I do a lot of research whenever I sit on judgment about it. I really work on, I go through all the medical literature. Similarly, in e-commerce, I'll have to really understand the complexities of the algorithms. Even the audit of algorithms, I really considered in one of those cases of where they said that they were expecting some results from advertising through online and all those things. So it's really very interesting. It's always a learning experience that way.
It sounds very exciting, actually.
Quite true.
Ma'am, one more question, ma'am. Can you explain the role of CCPA, ma'am, Central Consumer Protection Authority?
Yeah, it is a regulatory authority, central regulatory authority, which will proactively address all consumer complaints, suo moto, if there is anything that is against the interest of the consumers, whether it is misleading advertisements, whether it is misrepresentation, class action grievances also, whether it is with respect to builders, to promote consumer awareness. All these things are, I think, the CCPA is the central authority, regulatory body that will look into all these aspects of consumer protection. Yes.
Ma'am, on class action suits, have you received any class action suits so far?
Yeah, this was more a representative kind of complaint on behalf of all the flat buyers. So that was also considered very decently. We clubbed all of them and we adjudicated that matter. So that was against one of the builders, where there was delay in handing over the possession of the flats. So it was considered as the class action, although the common interest was the same, the subject matter is also the same, there was a little difference in the facts. So finally, the direction was to hand over the possession and also compensate for the delay. So that was one.
Ma'am, this because is there a possibility of multiple fora or forum shopping? Because, for example, for RERA issues, you can approach the RERA authority as well as a consumer forum. So when have you faced issues where there's a conflict, or do you actually drop any case because it is already with the authority?
First case where I have mentioned, the matter was sub judice before the High Court of Andhra Pradesh and Telangana. Still, as an alternative remedy, I think it provides the Act provides that it's an additional remedy that is provided under the Act, and alternative remedies can be simultaneously pursued. Because generally the relief asked under the Consumer Protection Act is quite distinct from what it is in the other remedies.
So you can go ahead and file a consumer complaint, though it is subject in other places.
Yes.
So it doesn't stop you from approaching the consumer forum.
Even if you have an arbitrary clause, they are entitled and they can come and file a complaint under the Consumer Protection Act.
I think this is very important, ma'am. I think people must know about it. Yes. Normally, there is a restriction against multiple forum shopping and all that.
Yeah, there is an express bar under that statute that they cannot approach the consumer court. There is nothing like that. But most of, I think that it's an additional remedy available for all the complaints if they are consumer disputes.
Yes, ma'am. Yes, ma'am.
Ma'am, is vice versa also applicable?
So
In the
you
same
mean,
scenario, like
see,
a case is already pending before consumer court, and can I also seek an alternative remedy before high court?
yeah,
Well,
that is the prerogative of the other court, whether to entertain or not. It is not like res judicata, I think.
ma'am, this is Murali. May I also seek one another clarity, ma'am? Like, see, the basic essence of consumer dispute redressal is the consumer should come to the court with a clean case, and he would be arguing his own case. In such a case, in such a scenario, if the advocates are discouraged to file the cases, and if the consumer himself is or herself is encouraged to file the case, the pendency in resolving the cases would, the time lag can come down. That is what I feel. Am I correct, ma'am, or is there anything? Because the law need not be interpreted in such a scenario where the dispute is with regard to the consumer. He can just cleanly come and tell that this is my area, this is my grievance, and the grievance can be addressed. If a law needs to be interpreted, then the advocacy comes into the role.
Very
is there
true.
any?
Yeah, a lot of complaints are filed by parties in person, and we generally, the staff there will help them in going about with the technicalities and filing affidavits and all that. That's no issue. The other side is even brings a lot of technical aspects of the law. I think the educating authority will definitely look into the merits of the case and decide. It's never a disadvantage to complainants to come and file their own case.
Thank you, ma'am. Thank you.
Anyone?
Do we have any more questions?
Ma'am, coming to this arbitration, though it has been stated in the thing, still why people prefer the consumer rights cases forum, ma'am? Any idea?
Pardon? Pardon, please come again.
No. See, in spite of being there arbitration clause, how the forum entertains the case for consumer cases, ma'am?
Well, it's the choice.
Once the arbitration should be arbitration, no?
No, well, it's
writing this, or is there any view for this?
Agree whether to approach under Section 11 or whether to approach for arbitration or to seek relief under the Consumer Protection Act. Perhaps he is willing to come to the Consumer Protection Act for some quick redressal. So there is no such embargo, I'm saying, under the Act, that if you are pursuing, if you have an arbitration clause, that there is no such embargo not to come and approach the Consumer Protection, Consumer Court.
Okay.
Hello, can I ask a question, please, if you don't mind?
Yes.
See, my name is Rajashekar. I just would like to ask you one small thing. You see, you mentioned about a case wherein, the consumer, I'm talking about that eye operation case where, that man fell down and went to, had an orthopedic operation, etc., suffering an injury and all that. See, nobody goes to a place where, they have to carry evidence, sort of thing. I mean, I would expand what I'm trying to say. You see, I don't go to a hospital assuming that, there will be deficiency of service. I would be thinking that, yes, I will be well attended to, I will be properly taken care of and all that. So, for example, in that particular case where that man, he fell down, he didn't anticipate, or his attendants did not anticipate he will fall down. So they don't carry cameras, etc., etc., etc. So your direction, that, that they're out to be attended to and all that. Actually, had it been mandatory on the part of that corporate hospital or wherever that gentleman had fallen down, you see, they had installed CCTV cameras there itself. That gentleman would have got perhaps a better justice.
Yeah, see, it's all about evidence, and whether the injury or loss caused to the complainant is attributable for any negligence or deficiency of service on the other side. So for lack of evidence, I think that complaint was partly allowed, giving a direction to the other side to install cameras in future to establish their case or defend their case. So that was a typical case where I am telling you, all medical negligence cases, it's very difficult to find direct evidence. Even there is a circumstantial evidence. I think it's very difficult under the Consumer Protection Act. So we will have to really rope in the NCI Medical Council of India to give us some kind of support and insights for adjudicating medical negligence cases. Yes.
No, please, I would like to just one more clarification or something. You see, had the consumer fora come out with some nominal compensation to the gentleman who had fallen down, saying that the non-establishment of CC cameras, etc., themselves is a deficiency of service. No, I'm just thinking it would have gone a long way. It would have gone a long way in providing proper attention to the patient or whatever. See, if the corporate hospitals know that yes, every minute their entire actions are being monitored through CCTVs, etc., perhaps they would have been more vigilant and attended to the gentleman. So in absence of the cameras or in absence of the wherewithals where, that evidence is automatically recorded, that way it would have been beneficial to the persons who are seeking the services. I mean, I felt this thing, if it had been, if such a case, I mean, to make the corporates more responsible, had the consumer forum given some sort of a bigger compensation, things would have been different. That is what I felt, say, all said and done, this itself is a great thing, nominal compensation being awarded to the persons. But anyway, I'm grateful to the consumer forum, that, they have come out with such a good thing, notwithstanding all this lack of evidence, notwithstanding that evidence has not been established, still, they're taking into account the accident as such, falling down or injuring or fracture or anything like that.
So the most important thing which I would like to suggest is to work across all sectors with the insurance authorities, with the Medical Council of India, with the banking sector, all the regulatory authorities. Suppose we work together for consumer protection and to bring in all those reforms which you are suggesting, to make mandatory for to install cameras in hospitals, to make things more clear. There is a contract, so the service level parameters are also defined in all the contracts of service. I think that makes a lot of difference in consumer protection. Yes.
No, remember, madam, I would like to say finally one more thing. That thing. See, nobody goes to a place anticipating deficiency of service, and he doesn't carry any equipment to record such a deficiency of service. See, I go to a hospital thinking that I'll be well attended to. I go to a bank thinking that I'll be well attended to. I go to a shop thinking that I'll be well attended to. So these kind of things, the onus should be on the service provider, that he should install certain wherewithals on his own as a mandatory thing. Otherwise, how things are happening. Say these crimes, etc., are covered because each street are having some, CCTVs, etc., so that people, that evidence is automatically recorded, so to say. Anyway, I'm thankful for, this is one thing that, the institutions themselves should be made aware of, so that, this thing, suppose I know that I'm under watch, then I will provide wherewithals, or I'll take more care. Suppose I come to know that I'm not having any watch, then maybe I may be myself negligent. That sort of thing happens, if you know what I mean.
Thank you. Thank you so much for your suggestion.
Ma'am, this is Murali again. In the very same case, ma'am, if the scenario is in regards to the government hospital, how would your view have been, ma'am, while giving the same kind of order, or would there be any change in your view considering to pass an order?
No. The face value of the parties never taken into consideration while adjudicating. No? So it all depends on the merits of the case, the evidence that is there on record, the inquiry, the investigation, everything is taken into consideration. Not about it's not about the parties, who are the parties involved in the case.
Ma'am, the difference is, ma'am, if you go to a corporate hospital and if you go to a government hospital, the word service itself is very much qualitative, and the service is widely different between these two sectors. Then how does that link?
See,
Am I audible?
Hello.
Yeah, he just wanted to know if he was audible.
Hello.
Ma'am, I'm there, ma'am.
Audible.
Am I audible, ma'am?
Hello.
Ma'am,
Ma'am, I'm present in the meeting. Ma'am, am I audible? I'm present in the meeting.
Oh, yes. Now, yeah. Can you tell me, please?
Ma'am, I was asking this. The very same word service, it varies widely when I go to a government hospital and when I go to a corporate hospital. Now that it is corporate hospital, the order is pretty good, pretty clear that there should be installation of CCTVs and the service would have been much better. Had it been a government hospital, the concept of service completely goes to a different perspective.
How?
Ma'am, the service and the hospitality that you get in a corporate hospital is completely different to what you get in a government hospital. For example, during the COVID or during the pandemic time, the kind of service that is provided at Gandhi Hospital, the kind of service that is provided at a corporate hospital is, there is a sea full of difference in this. They don't even care when a patient is admitted, when a patient is an inpatient in there. They might come only to the check at the morning and say that this, I mean, I need not explain in detail like how the service would vary, ma'am, but the kind of hospitality that you are given. The word service, again, it is a collaborative of many aspects, many parameters, I should say. Like one among them is hospitality. Today, the corporate hospital, that the point where do they make a difference is the kind of hospitality that they give you in, the kind of infrastructure that is built in, the kind of doctors and their hospitality towards the patient. It is not only the issue that the patient should be treated with. Patient should also be treated with the kind of hospitality and that affection that you show towards the patient when he comes in. That is what the service is, a parameter of many combinations. This is what I feel, man.
You
So
think
in such a scenario, if the same situation arises at a government hospital, the kind of orders.
You think that services should be commensurate with the payment or the consideration that you have given?
No, service should be compensated. The kind of service at a corporate hospital in the scenario, in the case study that we have dealt with, had it been in a government hospital, they would come out with a simple explanation that this is not a service that we are offering. We are here only to treat you. So the word service again varies widely. I mean, this is my personal view, ma'am. I may be corrected. Technicality of handling the disease or the issue might be same, one and same, or preferably it.
Hello. Hello.
Ma'am, sorry, ma'am. I think my connection is weak.
Maybe just to cut short the discussion, maybe like the question Murli was trying to ask ma'am is like, firstly, on the issue of jurisdiction, like does Consumer Forum have jurisdiction even against government's deficiency in service, like government hospital?
Yes. Yes, in the Shanti case, I think that was clearly mentioned in the Medical Association case. So that even in government, the services provided the government hospitals are also under the purview of the Consumer Protection Act. Yes.
Thanks a lot. I think we can. Swati?
Yes, ma'am. Ma'am, that was an awesome session. Thank you so much for patiently answering all the questions, ma'am. I'm sure the audience are immensely satisfied and they've immensely benefited from this enriching session. I also want to thank the audience for being so active and interactive. I'm sure, ma'am, you also had a good time interacting with the audience.
Experience for me.
Yeah, thank you so much.
Forward to many more such sessions. Thank you. Thank you.
Yes, ma'am. So just to
all this.
thanks, ma'am.
Swati and Pawan.
Yes, ma'am. Ma'am, so thank you so much for sharing the practical aspects of consumer litigation. So what I gather from what you say and from all the discussions we've had prior to this webinar as well, that alongside consumer activism, there is a need for activism from the member side as well. As you were saying, there is a need to set aside certain procedures, which normally courts follow. And then, the ultimate objective should be, protecting the consumer. So that kind of dynamism which I see coming from you, ma'am. So I hope and strongly wish that a dynamic member like you will take the cause of consumer protection ahead more and more. And as our own Mahatma has said, that consumer is the king. So from the previous regime of, consumer beware, we are moving towards the seller beware regime. So I hope this and as you said, it needs just more than consumer awareness. As you said, the regulatory authorities also must take up certain actions to protect the consumer even before a litigation comes up. So that is what is my takeaway from this webinar, like from what various people have been saying. So it is not just that we never anticipate that you're going to get a deficiency in service. And then normally even the authority as well is not aware. Nobody anticipates that this kind of issue or scenario arises. So I think there's a need for an institutional mechanism and then a multidisciplinary approach, multi-faceted approach for protection of consumers. So a small token of appreciation from our side, ma'am. Thank you so much, ma'am. A small certificate.
Thank you so much. Wow. Fantastic. Thank you so much. God bless you.
Right. Thank you so much. And
thank you. I sign off.
Yeah, we formally come to an end of this session. As you said, ma'am, we look forward for more such sessions and look forward to meeting you sometime, ma'am. Yes.
Yes. Your feedback is most welcome from all the participants. Thank you so much.
Thank you so much, ma'am. Yeah. I'll be ending the session now.